I'm here at the scene of the crime spree, right behind me.
Strange. Vice Mayor Strange, you'll address her properly.
You can kiss my foot.
Mr. Rickard, you're out of order.
FBI, we are asking you to investigate this council. Please look into this council, how they award contracts, the bid process, how they use their positions to benefit their friends and themselves, how they use their positions to attack residents and critics and neighbors and business competition. FBI, will you please look into this?
And I welcome the FBI here. If you notice, Mr. Thompson, with his plea for the FBI and his watchdog group, this city runs the cleanest in this whole county. I guarantee
He was served a federal subpoena this morning.
Did receive a subpoena this morning, and we're going to cooperate 100% with the subpoena. And
Most of you who were involved up here, you gaslighted me. You tried to say I was crazy. And now we know that that's not true. And there's a lot of other issues I've been asking about as well.
All right, today the much anticipated ruling has come out. Judge Walker has issued his ruling, and I know I'm starting a little earlier than normal. This is a big one, though. This is a big show today. So would you help me notify folks, because I know Facebook doesn't always notify people. Will you tag people you think want to see this? Will you share it if you think it's worth sharing? WMBB is going to love this story, and I think they're going to misconstrue the story. This is really an amazing situation that we find ourselves in, because you know what it does is it means we're going to trial in 3 weeks, 26 days, 25 days. What is it? Yeah, it'd be on the 27th. It's on a Monday. It's in Tallahassee. You can watch it. I told you about the witness list yesterday. It's incredible. So I'm gonna show you the entire ruling, the 16-page ruling. I have highlighted it. I've underlined it. I've tried to understand it, and I want to convey to you what it says. Essentially, it's this: Judge Walker denied the defense. What it is it's the defense's motion for order to show cause and third motion to compel. And part of that was the bad actor list and the bad acts list that the defendants submitted by order of the court because of the evidentiary hearing December 12th and 13th. So what does that mean? He denied it. Well, it means we're going to trial. And essentially what he said was that any misconduct that the defendants identified was limited at most, and in some instances was not misconduct at all, and therefore it does not rise to the extraordinary level that it would have to rise to in order for a court to dismiss an indictment before a trial. It almost never happens. I don't know what the percentage is, but I'll bet it's less than 1%. And it didn't happen here either. And nobody should be surprised about it. If I were a defendant, I would be disappointed. And if I were the prosecutors and the investigators, I would be two things. I would be relieved, right, that the judge didn't say, issue a sanction against me. But I would also be worried beyond today. Well, this is the way I would handle it if I was a prosecutor or an investigator. If I was on the list, if I was, say, the FBI agent or the sheriff's public trust unit, the guy cracking down on public corruption, Major Stanford, or if I was Chief Ramey, or if I were, city manager Vicky Gaynor, anybody on the list, or any of the prosecutors, I would be celebrating tonight. Lots of apple juice, about 94 proof. That's the kind of apple juice. It's the only time I get any vitamin C. But I would wake up tomorrow scared as all get out, because that means we're going to trial. And that means I'm going to be on the witness stand, because what Judge Walker said was that the proper remedy for any misconduct outlined by the defendants is cross-examination. Whoa. Could you imagine having to sit up on the witness stand and be cross-examined about all of the stuff we've been talking about? What Judge Walker said today is that is the appropriate remedy. Out of fairness, no. He even said no. But out of the constraints of the law, yes. I told you I thought there would be some sanctions, lesser sanction issued. So this is a mixed bag, really. I just told you why it's a mixed bag for the people on the quote bad actor list. For the defendants, it's also kind of a mixed bag. Of course, they wanted it to be dismissed altogether, wouldn't you? Because then you don't have the jeopardy of the rest of your life being left up to 12 people you don't know, a jury, right? So I guess the bottom line here is today's ruling means that the defendants, former Lynn Haven Mayor Margo Anderson, developer James Finch, they're in jeopardy. But it also means, in my opinion, that there are a lot of other people in jeopardy that have to go up on the witness stand and have a lot of explaining to do. Just because you don't get sanctioned pre-trial doesn't mean that you won't get your ass handed to you during the trial. If you've ever seen Mark Walker in a courtroom, he doesn't play. So if you are in the gallery when the trial takes place in Tallahassee starting Monday, February 27, and you hear some shocking stuff, you better not gasp, you better not sigh or exhale or jump or make any sudden movements, because Judge Walker will throw you out of the courtroom and maybe even have you arrested. That's how serious he is about not distracting the jury, about keeping the conduct of the court appropriate. So if you go, you got to comport yourself exactly the way he says so. But it's going to be difficult because it's going to be shocking as all get out. Here's the other thing. The only way, this also guarantees, no, I guess nothing guarantees anything, but this also makes it much more likely that real corruption is going to be exposed, because the evidence, some of which we've already seen, is going to point in other directions. And boy, is it going to be explosive. So if he had dismissed everything, we would never, we'd see some of it because he's releasing a lot of it, but there's a lot of stuff we would never see and we would never know. So there's a whole lot of people who are going to be in jeopardy in order for the truth to come out, in order for the truth to have its day. Now, do you want to see the order? I've underlined it. I've highlighted it, and we'll read through it together. Today, the letters are bigger. I know yesterday you had to have a magnifying glass to see it, but today you'll be able to see it. And I'm going to show it to you right after this. Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm Al Saulene, your Panama City Beach lawyer. 850-215-0628.
All right, let's get right to it. Booyah, look at that. That's the much anticipated ruling came out today. Let's read it. This is the order denying defendant Finch's motion for order to show cause and third motion to compel. It's the bad actor list and the bad act list, basically. All right, so I guess I'll read you just about all of it, but we'll emphasize the highlighted parts. This court, and Judge Walker, has considered defendant James Finch's amended motion for order to show cause and third motion to compel. The government filed a response in opposition. The court then held a hearing, the evidentiary hearing, on the matter December 12th and 13th, during which defendant Margot Anderson joined the motion. At this court's direction, defendants filed a supplemental briefing. That's the bad actor list. The government filed a response to the supplemental briefing, to which defendant Finch filed a reply. Finch's motion is now under submission and ripe for disposition. For the reasons set out below, Finch's amended motion for order to show cause and third motion to compel evidence, show cause why they haven't provided the exculpatory evidence, is denied. The parties are familiar with the procedural history of the case, so this court will only recite the portions relevant to the present motion. The third superseding indictment in this case charges defendants with various crimes concerning public corruption. The court previously afforded defendants access to materials and transcripts presented to the first, second, and third grand juries. That happens less than 1% of the time. And boy, what we found out in those transcripts, this is the biggest lesson of this whole case if you consider it beyond the defendants themselves. Defendants in a federal prosecution like this never ever see or hear what they told the grand jury to get the indictment in the first place. Without that, these defendants would never have known all the false information told to the grand jury to get the indictments to begin with. And that's the case for 99+% of defendants. Seems to me that there should be some reform with regard to that. Following a showing of particularized need to prepare a motion to dismiss the indictment for government misconduct. That's why they got to see it back then. Citing these materials as well as the government's subsequent conduct, the government being the prosecutors, during its investigators and litigation of this case, defendants filed the present motion seeking dismissal of the operative indictment, the only remaining one, or a variety of lesser sanctions. Defendants raised two arguments in favor of dismissal. One, the government violated Brady, getting all the evidence to defend themselves, and this court's orders on several occasions, meriting sanctions under this court's supervisory authority. Two, violated the vindictive prosecution doctrine. That's what the defense said. Defendants also seek to compel the government to produce materials from a search warrant served on GAC contractors on Brady grounds. In other words, there's evidence in there that will show we didn't do it. The government argues, the prosecutors, that both of defendants' arguments for dismissal or other sanction lack merit, and that as to the motion to compel production of GAC materials, the defendants have already been provided with access beyond what the law requires. This court will address each in turn. First, the defendant's argument for dismissal due to chronic government misconduct. Specifically, defendants claim that the government's flagrant repeat violations of this court's orders and intentional suppression of Brady information merit dismissal under this court's supervisory authority. Defendants recite many of the same alleged instances of misconduct they raised in their first motion to dismiss for government misconduct. Defendants also allege several new instances of misconduct ranging from the government's suppression of material seized pursuant to the GAC search warrant to its decision to file a third superseding indictment, the prosecutors, with a different theory of liability after gaining insight into the defendant's strategy by way of their timely filed motions in limine. Finally, at the evidentiary hearing, Defendants elicited testimony showing what they claim are multiple instances of the government seeking or presenting inculpatory information while ignoring or disregarding exculpatory information. In other words, stacking the deck. The government disagrees, though, the prosecutors, arguing that it has met its discovery obligation and is acting in good faith to resolve the case on its merits and fairly resolve the discovery issues. Further, the government insists that many of the defendants' allegations of misconduct are unfounded and that the proper remedy for many of their grievances is cross-examination of witnesses at trial. That's what the prosecutor said, and the judge agreed. And now they're going to get what they wish for. Wow. I can't believe it's going to this. This, you always have to consider the jeopardy that defendants are in, but for a society to be cleaned up, the Band-Aids have to be ripped off, and we've got to look at what the hell's going on around here. And this is the thing that they worry about most. We saw the superintendent of schools retired or announced his retirement. I would not be surprised. Remember this. I would not be surprised if we see more resignations, retirements, early retirements, where people involved in this want to be sure to protect their benefits and secure them. I have been told this. I was told this a little more than a year ago. Watch for early retirements, and boy, there were a bunch. I wouldn't be surprised if we see some retirements from all over the place, even at the sheriff's office. All right, let's keep going. I don't want to speculate. I want to get back to what we have here in front of us. Federal courts may, within limits, formulate procedural rules not specifically required by the Constitution or Congress. Now he's citing case law, what he's allowed to do, what he's not allowed to do as a judge in a situation like this. These supervisory powers deal strictly with the court's power to control their own procedures to prevent parties from reaping benefit or incurring harm from violations of substantive or procedural rules. The district court in United States v. Noriega summarized the law governing this doctrine. All right, this is the doctrine under which Chief Judge Mark Walker is operating. His supervisory authority to dismiss the whole thing, which is basically never done, is in essence a judicial vehicle to deter conduct and correct injustices, which are neither constitutional nor statutory violations, but which the court nonetheless finds repugnant to fairness and justice and loath to tolerate. That's pretty much what he said in the evidentiary hearing on December 13th. He said, look, a lot of this is unfair. It's just wrong. It's reckless. And out of fairness, I might do something else, but I can't act out of fairness. I can only act out of what constraints are on a court based on case law. And so that's what they're talking about. That's what he's citing here. As invocation of supervisory power, to dismiss an indictment is a harsh remedy. It is reserved only for flagrant or repeated abuses, which are outrageous or shock the conscience. It is certainly not to be applied as a remedy for mere technical illegalities or inadvertent violations, as, quote, these powers should not permit the criminal to go free because the constable blundered, end quote, citing case law. All right. As with defendants' previous motions to dismiss for government misconduct, this court does not discuss every allegation regarding misconduct set out in the hundreds of pages of briefing and the hours of testimony presented at the evidentiary hearing. However, this court has scrutinized every allegation in the filings as well as those presented at the hearing. But as explained in greater detail below, this court declines to exercise its discretion to dismiss an indictment pursuant to its supervisory authority. And then he has a footnote there, but I'm not going to cover that. Defendants fall, but you can, because I'll post all this. Defendants fall short of demonstrating outrageous or conscience-shocking government misconduct necessary to persuade this court to exercise its supervisory authority or to dismiss the indictment. The court previously addressed some of the conduct that defendants cite, like the government's actions before the first 3 grand juries and discovery shortcomings. That's when he called last year. That's when Judge Walker said that their conduct right there on those 2 things were unprofessional, haphazard, and reckless. See, that all doesn't go away. It's just for a jury to decide. And the court declined to find that it warranted dismissal of the indictment. For example, defendants claim that the government repeatedly presented misleading or false information to the grand juries while deliberately failing to present readily available exculpatory information. As this court previously explained, the alleged wrongdoing consisted either of non-issues or conduct that did not merit dismissal. While this court acknowledged that cumulative conduct from the government may merit dismissal, even where isolated incidents do not, this court declines to find that this conduct merits dismissal now, either on its own or when considered cumulatively with defendants' new allegations. As for new alleged wrongdoing, by the way, let's take a look at that footnote. At the hearing on this motion, December 12 and 13, this court entertained the argument whether the government's alleged misconduct had a material effect on the various grand jury's decision to return an indictment, and whether the alleged misconduct is effectively cleansed by a new grand jury returning the operative indictment. This legal standard comes from a claim to dismiss an indictment due to government misconduct in front of a grand jury, and that case, which is the controlling case on this. In other words, when a prosecutor, when they go, the FBI, the prosecutors, when they go to a grand jury and tell the grand jury all kinds of bad stuff about you, that case has set the standard, cavallo. They do not have to tell the grand jury the whole truth. They can tell them what they have probable cause that you did illegal, but they do not have to present the rest of the story. They can hide any exculpatory evidence and only tell them a one-sided story. But there's a line they can't cross. And the judge said, we don't see that it's crossed. Defendants do not, however, defendants do not, however, raise this argument here. Instead, they seek to dismiss the indictment for government misconduct, generally pursuant to this court's supervisory authority, which is guided by a different standard. See supra. What is supra? Supra is up. See, look up. See up there, the writing up there. All right. So now, for new alleged wrongdoing, defendants also fail to show that the government's conduct merits dismissal. For example, defendants point to the government's filing of several flawed indictments as evidence of its knowing violation of this court's orders and various rules of law. While this court has previously cautioned the government about continuing to submit faulty indictments, could you imagine? Your whole life's on the line because the government submitted multiple faulty indictments, and the court has no ground to throw it out. It's up to a jury. That's what we're learning here. By the way, you always hate to do this at others' expense, but isn't it great to learn, right? To learn this process. How much have we expanded our minds and our understanding? Some people say, I already knew it all, Bernie. You're the only one learning this stuff. We told you a long time ago on a Facebook meme. Okay. All right. You know, Supreme Court Justice Oliver Wendell Holmes has a quote that I love. He said that man's mind stretched to a new idea never returns to its original dimensions. I've learned a lot about this stuff as I present it, study it, and all of that. As let's see. All right. So while this court has previously cautioned the government about continuing to submit faulty indictments, the government's most recent flawed indictment, the most recent one, does not evidence the government's bad faith. The third superseding indictment, the one now, suffered from a different type of duplicity than the first three indictments. And given the simplified nature of the charges relative to previous indictments in the case, the defect can be remedied with a jury instruction. This is when the judge recently severed Antonius Barnes from Margot Anderson in their relationships to James Finch. Further, defendants' grievances with the government's handling of the GAC material, as explained infra, are unfounded. Now, what the hell's infra? We learned what supra was. It's up above. I'll bet you infra means below, which it does. The court also finds that defendants' alternative remedies, not just throwing the whole thing out, but lesser ones, are not warranted. The bulk of defendants' grievances concern the government's allegedly shoddy investigation and its selective presentation of allegedly exculpatory information. Here we go. Look at this. Look at this footnote here. Defendants also cite that the government's alleged violation of the Sixth Amendment, attorney-client privilege, by having an informant contact them and discuss case-related issues as cause to dismiss the indictments. However, as this court has explained, quote, the vast majority of conduct defendants complain of did not violate the Sixth Amendment, although some conduct was a closer call. And he didn't decide that in this, because the lawyers didn't ask him to. Look, because the appropriate remedy for such a violation would be to suppress the government's ill-gotten evidence and defendants sought only dismissal, this court declined to determine whether a violation occurred. It wasn't asked, and we declined to do it. While it was a close call, he says, as to whether the alleged misconduct is a violation of the Sixth Amendment, it does not merit dismissal either on its own or when considered cumulatively. While the defendants seek dismissal or other lesser remedies in the present motion, they still do not specifically seek to suppress the fruits of the government's alleged misconduct. So that makes me wonder if maybe the attorneys didn't ask for what they should have asked for specifically there. And everybody knows the defensive attorneys have done a bang-up job. But you don't get everything right, and Judge Walker's not going to just hand it to you. You got to ask for it. Even assuming the government committed a limited violation of the Sixth Amendment, this court again declines to impose any sanction. And as I underlined above, Judge Walker declined to even determine whether a violation occurred because it wasn't asked for a lesser sanction. Okay. Okay. Defendants' cross-examination of the government's witnesses will be sufficient to assuage their concerns. So essentially, that's what this comes down to. Judge Walker says, look, there's some stuff here, but it doesn't rise to the level of throwing this out or even issuing lesser sanctions because of the nature because of the nature of the conduct. That's for a jury to decide if this was fair, not for the court. So this court declines to exercise its discretion to use its supervisory authority to sanction the government for misconduct. Again, it almost never, ever happens. Next, the defendant's vindictive prosecution claim. Citing examples of the government's conduct ranging from its refusal to discuss voluntary surrender before indicting Finch to its repeat attempts to manufacture a conflict of interest. That's what the defendants accused them of. And I'm going to tell you about that right after this.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
It's a hot time in Florida, and my friend Ryan can make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com.
Defendants claim they have submitted evidence of actual vindictiveness. Having shown the government acted with actual vindictiveness, defendants argue this court must dismiss the operative indictment. Defendants also contend that if they fall short of showing that the government acted with actual vindictiveness, they are entitled to a presumption of vindictiveness at the pretrial stage, where we are now, which the government has failed to rebut. The government, prosecutors, argue that defendants failed to demonstrate actual vindictiveness or present sufficient evidence to entitle them to a presumption of vindictiveness. That's up to a jury. Deciding whether to dismiss an indictment for prosecutorial vindictiveness rests in the discretion of the district court. So here's where Judge Walker, and this is how it always works, he'll recite their arguments, then he'll cite case law, and then he'll analyze it and give his ruling on each of these areas of concern. So it rests in the discretion of the district court, the 11th Circuit. Quote, this is case law now, a prosecutor may seek a superseding indictment at any time prior to a trial on the merits, so long as the purpose is not to harass the defendant. Remember, this is the fourth superseding indictment, the fifth write-up of an indictment on Margot Anderson, and the fourth draft on James Finch. So basically that means that prosecutors can amend, augment their indictment and supersede the last one. And there have been 5 iterations in this case alone, which is practically unheard of. But case law says they can do it, and they did. As a general rule, as long as the prosecutor has probable cause to believe that the accused has committed a crime, the courts have no authority to interfere with a prosecutor's decision to prosecute. You see how the courts are limited in what they can do? A superseding indictment adding new charges that increase the potential penalty would violate due process if the prosecutor obtained the new charges out of vindictiveness. Well, that leaves a lot of room for it can be pretty subjective, right? But the key here is these indictments have not increased the potential penalty because they've gone from more charges to less charges. All right, so the judge considered that. Defendants have 2 paths to prove a prosecutorial vindictiveness claim. They can either, 1, put forth direct evidence of actual prosecutorial vindictiveness, like maybe a text or something that says we're going to get these 2 SOBs, the Bonnie and Clyde of public corruption in Bay County, even though we're planting evidence and even though we're lying. I mean, if there was a text that said that or evidence that they were doing that, that would be one thing, the judge says, direct evidence. Or 2, benefit from a presumption of vindictiveness where the facts show a realistic probability of vindictiveness. In determining whether a presumption of vindictiveness should apply, a court must first determine whether the defendant's exercise of pretrial rights was followed by charges of increased severity. Remember, these were decreased severity in the superseding indictments. Where a defendant shows nothing more than his assertion of rights through pretrial motions, followed by augmentation of the charges against him, there are no compelling factors which would justify invoking the presumption of prosecutorial vindictiveness. That's the standard set by case law. Defendant's prosecutorial vindictiveness claim fails, says the judge. Now he's analyzing it. Their arguments and the case law. They fall short of showing actual vindictiveness or a realistic probability of vindictiveness. None of defendants' factual allegations rise to the level of actual vindictiveness. Quote, actual vindictiveness requires direct evidence, such as evidence of a statement, like I said, by the prosecutor, which is available only in a rare case. Look at this footnote. This court notes that in Barner, the 11th Circuit declined to expressly hold that a presumption of vindictiveness can ever arise in the pretrial setting. So, in other words, the court said it could. The 11th Circuit said it could happen. All right. It declined to hold that it can. It declined to expressly hold that a presumption of vindictiveness can ever arise in the pretrial setting. Instead, they found that if the presumption could apply in the pretrial setting, the defendant there failed to show a realistic probability of vindictiveness that would be required for such a presumption. All right? If it could doesn't mean that it did, and it failed to show a realistic probability. So the bar is unbelievably high. That's page 9, by the way. All right. This court already addressed much of this alleged misconduct in a previous order in which it found that dismissal was not merited. But that's the order last year where Judge Walker called their conduct reckless. Also, many of the new allegations of misconduct are non-issues, he says. For example, defendants claim that the government repeatedly attempted to manufacture a conflict of interest to seek disqualification of Anderson's counsel. This allegation, however, distorts what actually happened. So the judge isn't buying the defense on this one. Shortly after Finch was indicted, the government filed a motion noting that Finch appeared to be paying for Anderson's counsel, citing its duty, as well as this court's duty, to ensure Anderson received conflict-free representation as guaranteed by the Sixth Amendment. The government requested a hearing to address a payment arrangement that presents a potentially serious conflict of interest. This court held a hearing on the matter, explaining the conflict to Anderson before she knowingly and voluntarily waived the conflict. So, since she did that, the judge said, all right, this is okay. The conduct fails to show actual vindictiveness by the government. In fact, it shows the opposite, he says. The Florida rules of professional conduct prohibit lawyers from accepting compensation from a third party unless the client gives informed consent. There is no interference with the lawyer's independence of professional judgment or with the client-lawyer relationship, and confidential client information is safeguarded. And where an alleged co-conspirator is the third party, paying for an individual's legal fees, a potential conflict becomes glaring. Understandable. Recognizing the inherent dangers arise when a criminal defendant is represented by a lawyer hired and paid by a third party, particularly when the third party is the operator of the alleged criminal enterprise. Here, the government acted to safeguard Anderson's Sixth Amendment right to conflict-free representation, which is implicated by a co-defendant paying for her representation. At most, defendants' allegations of actual vindictiveness are better characterized, says Judge Walker, as pretrial skirmishes with the government, to which the doctrine of prosecutorial vindictiveness does not apply. As to defendants' attempt to demonstrate entitlement to a presumption, they failed to show a realistic probability of vindictiveness, entitling them to a presumption. First, this court notes that defendants failed to make any showing that they face charges of increased severity following their invocation of a pretrial right. Second, their allegations of misconduct failed to show a realistic probability of vindictiveness because, as discussed above, this court found that either the government did not do anything wrong, the allegations amounted to sloppy conduct rather than misconduct, or the allegations demonstrated limited misconduct that did not merit dismissal. Accordingly, the prosecutorial vindictiveness claim fails. Finally, the defendant's motion to compel the government to produce materials from GAC search warrant. The defendants argue that the government suppressed materials from the GAC search warrant that should have been disclosed pursuant to Brady, Giglio, and the court's discovery order. Because the government failed to disclose this material to defendants, they argue this court should dismiss the indictment with prejudice. The government argues that defendants have failed to show any entitlement to the GAC material. Despite this, the government notes it has not suppressed information from the GAC search warrant because it made this material available to defendants for inspection and copying. So he just recited their arguments. Now what's he going to do? He's going to look into case law. He's going to examine case law on the matter. And it says, at any time, the court may, for good cause, deny, restrict, or defer discovery or inspection or grant other appropriate relief. When a party fails to comply with discovery orders, the federal rules of criminal procedure authorize this court to compel disclosure, grant a continuance, prohibit the offending party from introducing the evidence at trial, or enter any other order that is just under the circumstances. As for the procedure in which the government must make discovery available to criminal defendants, quote, the government must permit the defendant to inspect and copy documents if the item is within the government's possession, custody, and control, and the item is material to preparing the defense. The government intends to use the item in its case in chief at trial. Its main argument. The item was obtained from or belongs to the defendant, but the government is not obligated to make copies of discovery items, according to case law. In fact, district courts abuse their discretion by ordering the government to make copies of discovery where the defendant has in no way been prohibited from inspecting the particular documents and cannot demonstrate an undue hardship from this availability, especially where the defendants are not indigent. And finally, this court must always keep in mind, says Judge Walker, that its foremost function is to hear all relevant evidence in an attempt to reach a truthful and reliable verdict. I should have underlined that because I almost feel like Judge Walker is sort of whispering something here, which he would say, don't say that about me, Thompson. Don't make assumptions about me. I'm not whispering anything. I wrote it down there, and there needs to be no commentary on it. That's exactly what Judge Walker would say. So I hope he's not watching. But I look at this, and I would never try that in the courtroom, just on my show. Is he laughing? This court must always keep in mind that its first and foremost function is to hear all relevant evidence in an attempt to reach a truthful and reliable verdict. In other words, if he had sanctioned some of these bad actors that the defense claims are bad actors, it would never have gotten to the jury would never have heard it. We would never have heard it. So by following the strict rules, case law, all the relevant evidence is going to reach the jury. The defendants are going to be able to talk about it and make the case where the judge says it's appropriate at trial. If he had sanctioned them, that stuff wouldn't have been at trial. And in a weird way, the defendants may not have had a chance to make their strongest case. And we certainly wouldn't hear what I think we need to hear. Interesting. Defendant's motion to compel production of GAC material or in the alternative dismiss the indictment for the government's failure to produce the GHC material fails because the government did not suppress the material, says Judge Walker. As Finch acknowledges in his motion, the government offered defendants access to GAC material at the FBI office in Panama City, where they could copy any document that they find relevant. Counsel for Finch rejected this. This was Guy Lewis. Because of the cost and inconvenience of traveling hundreds of miles from the office while working toward complying with other deadlines in the case. In other words, says Judge Walker, defendants are not alleging that the government prevented them from having any access to the GAC material. They're alleging that the government refused to provide them with copies of all the material seized. So he says defendants fail to show that the government suppressed the GAC material where it offered sufficient access to on defendant's request. Neither this court's local rules nor its discovery order, in this case, directs the government to make copies for the defendant's use. And the footnote here says this court previously rejected Anderson's argument that the government must identify all Brady material within a larger production of documents. This court noted that ordinarily, the government need not go through its production and specifically identify all material that may be beneficial to the defendant. However, this court also noted that the government should not be permitted to circumvent its Brady obligations by burying exculpatory material in hundreds or thousands or millions of documents. For this reason, this court denied Anderson's request for the government to identify specific Brady material within a larger production without prejudice, to allow Anderson to make a showing that the produced discovery was so voluminous as to require identification. In other words, we made that decision back then without prejudice, meaning she can raise that argument again, but Anderson did not attempt to renew that part of the motion or to make that showing here. Instead, defendants seek an order directing the government to identify Brady material in the GAC production as a sanction for misconduct, which this court declines to issue for the reasons set out above. All right, we're almost through here. This is it. Last page and a half. This is especially relevant like here, where like here, indigency is not an issue for either defendant. Both Anderson and Finch have retained counsel with offices some distance from the site of this criminal investigation, which is their right. However, says Judge Walker, defendants cannot hire out-of-town counsel and then complain about the need for them to travel to litigate this case. Accordingly, defendants' grievance with the government refusing to make copies on their behalf does not merit dismissal, and this court declines to exercise its discretion to order the government to make copies for the defendant's benefit. Here we go. This is the order. Defendants fail to show that dismissal of the indictment is merited for the government for government misconduct. These are the three things here that Judge Walker said these do not rise to the level of sanctions. These are for the jury to hear about. So these don't go away. The proper remedy is just a different place, trial, where this will all come up again. Defendants fail to show that dismissal for the indictment merited for 1, government misconduct, 2, violation of this court's orders, or 3, vindictive prosecution. Defendants also fail to show an order directing the government to produce the GAC material to defendants is merited because this material has already been made available for their inspection accordingly. It is ordered. Finch's amended motion for order to show cause and third motion to compel is denied. And 2, Anderson's supplemental filing and request for alternative relief is denied to the extent it can be construed as a separate motion. And 3, the clerk is directed to terminate Finch's redacted amended motion for order to show cause and third motion to compel. So ordered today. Judge Mark Walker, Chief Judge Mark Walker. Wow. So this was the much anticipated ruling I'll be reading your comments a little bit later. As I stated before, the judge denied it all. And by doing so, that means all this evidence goes in front of a jury and you get to see it all. Had he sanctioned any of it, we may not have ever seen it. And a lot of it involves the people named in the defendant's list of bad actors. The judge didn't say there are no bad actors. The judge said this stuff doesn't rise to the level of what I can do about it. Tell a jury. That's all you can do. So they will. And that includes the FBI agent. It includes the Major Jimmy Stanford. It includes Police Chief Ricky Ramey. These are all people going to be cross-examined, which is the appropriate remedy, the judge said. Vicky Gaynor, the current city manager, and the former city manager, Michael White. If you like to sit on your couch and watch courtroom dramas, nothing like the real thing. And it begins Monday, February 27th in Tallahassee. And if too many people show up and you can't fit in the gallery, Judge Walker said he's going to open up a bigger courtroom so that you can come in and watch the proceedings, where the witness list also includes Sheriff Tommy Ford. What's that going to be like? Wow. The crescendo, the big ending continues here. What's next? I'll tell you. So the judge now come some really big rulings. Okay, this is what's next. The judge is going to say what evidence is permitted and what evidence is not permitted at trial. The defense, they want everything. Lay it on us. Tell the jury all the bad stuff, and let us go to town and present evidence why it's not true. The prosecutors, on the other hand, they say, you're right, we do want to tell everything, but we don't want you to say anything. The prosecutors are trying to, their motion in limine has like 29 things they don't want the jury to hear, like James Finch's health. Like, what are the property lines of Margot Anderson's home? Like, what about the false statements and the shoddy, potentially vindictive investigations and all that? They don't want any of that talked about. In other words, anything to defend yourself, the prosecutors don't want in that trial. And Judge Walker is going to rule on those next. That is what's going to set the stage for the outcome, I think. All right. I just want to thank you for being here. And if you think this is important stuff, I hope you'll tag your friends. I hope you'll share it. And look at it, with some humility. Try to learn some stuff. Learn so much through this. I just think it's important for us to first seek to understand, right? And then, for me, seek to explain it. And there's a lot to learn here. I've been learning a lot about this stuff, haven't you? Okay, so I want to thank the Unknown Patriot, as always, for supporting my efforts. And if you would like to support my efforts, I sure could use it. The only reason I can tell you this stuff is because I'm independent. You can become a patron at patreon.com/Bernie Thompson, patreon.com/Bernie Thompson. Or you can become a sponsor. You can become another Unknown Patriot if you choose to, if you want to support my efforts to bring this to you, as I couldn't do it without you. I barely do it now. But it's important stuff. What a time to be a watchdog, huh? What a time to be a watchdog. There's a lot of local stuff. A lot of local stuff's happening. The Shadow knows a few things. And I'll tell you when the time is right and the mood is proper. Thanks for being with me.